My name is Brandon Smith. I'm the president of K-Law's Federalist Society chapter. Federalist Society is a nonpartisan organization that has three basic beliefs: separation of powers being fundamental to our government, judicial restraint, and a checks and balances system. If you want to know more about that, we can talk about it later. I'm sure you'll learn a lot about these policies today with Professor Levy or Mr. Levy talking to us. Thank you all so much for coming out today, especially the Wednesday before fall break. Make sure you enjoy some pizza in the back. I also just want to recognize a few people before we start that I didn't do this at the last event. Can the officers stand up real fast or kind of wave your hands? If you have questions about Federalist Society events, you can grab one of these guys or gals and they'll help you out. They've been real important in the planning of this event. I'm going to go ahead and introduce you today a professor we all probably know, Professor Stephen Ware, Contracts and ADR Extraordinaire. He's going to introduce our speaker today, the distinguished Dr. Robert Levy. So, Professor Ware.
Thanks, Brandon. I wanted to introduce Bob Levy because I first interacted with him almost 10 years ago. I wrote a paper that was published by his organization, the Cato Institute. And at that time, Bob, I guess, was my editor, and he and I interacted a lot over the phone and email, and I was very impressed by his intelligence and his capabilities. And so I just wanted to say a couple things about Bob, which I just did, and the Cato Institute, his organization, because it is the leading libertarian think tank, I guess I'll call it, in Washington, D.C. And that's an important thing to people like me who are libertarians, because we tend not to have a whole lot of influence in Washington, D.C., and Cato is a big part of the little bit of influence we do have. And libertarian views, insofar as they're represented, tend to be not very consistently represented. There's a lot of conservatives out there who may agree with some libertarian positions on economic issues, but disagree with libertarian positions on foreign policy or social issues, and then many liberals who have the opposite view, agreeing with some libertarian positions but not others. So it's hard to find sort of principled, consistent libertarians in Washington, D.C., but Cato Institute is it. They're the real deal, real principled libertarians. And I say this as a principled libertarian myself. Many principled libertarians are crackpots, are nuts, are crazy people, and that's not Cato. Cato are serious, sophisticated people who do serious, sophisticated work. So with that, I introduce from the principled and not crackpot Cato Institute, Bob Levy.
Thank you very much. I'm going to take off where Professor Ware left off, and that is talking about libertarian philosophy, in particular how it differs from, in its view of the Constitution, from conservatives and from liberals. Now, I am going to talk about this book, The Dirty Dozen, which is for sale at a shamefully reduced price outside. This is about how 12 Supreme Court cases radically expanded government and eroded freedom. But before I do that, before I talk about some of the cases, maybe 4 or 5 of them, I want to set the stage with a few comments on these comparative views of the Constitution, liberals, conservatives, and libertarians. When I talk about libertarians, I'm not talking about the Libertarian Political Party. I'm talking about a political philosophy that focuses on free markets, private property, individual liberty, and strictly limited government. So at Cato, we don't endorse candidates, we don't endorse parties. As you're soon going to hear, we're critical of the Democrats, the Republicans, the conservatives, the liberals. We do have a consistent minimalist view of the proper role of government. Conservatives tend to agree with us on economic, budget, tax, regulatory issues. Liberals will agree with us on the social issues, on civil liberties issues, and on the non-interventionist foreign policy. And that's because liberals and conservatives are both inconsistent in their views. And to illustrate that, I want to posit a constitutional framework for you to consider. I think the structure of our federal system can best be captured, and the structure of the U.S. Constitution can best be captured by looking at the final 2 provisions of the Bill of Rights. How many of you have had common law already? So not too many. So the 10th Amendment and the 9th Amendment are the final 2 provisions of the Bill of Rights. The 10th Amendment, which you're going to learn when you take common law, says essentially the national government can exercise a certain set of powers that are enumerated in the Constitution. They're listed there mostly in Article 1's Section 8 of the Constitution. And the 10th Amendment goes on to say if the powers aren't enumerated, the federal government doesn't have them. They're reserved to the states, or depending on the provisions of state law, they're reserved directly to the people. Now, what powers are we talking about? Things like coining money, establishing post offices, regulating interstate commerce. You'll find a long list of them, less than 20, in Article 1, Section 8. Now, these powers that are expressly enumerated in the Constitution lead to a very narrow view of federal authority, and libertarians and conservatives tend to agree on that narrow view, but there are a couple of key exceptions. The first of which is that many conservatives, but not libertarians, are willing to federalize, assign responsibility to the federal government, a significant amount of both criminal law and civil law. If you want an example in the criminal law area, take a look at our feudal, totally ineffective war on drugs. There is no constitutional authority for the federal government to be mounting a war on drugs. Criminal law is traditionally and historically and constitutionally the function of the state government. If you want an example in civil law, take a look at our current health debate with the pressure from conservatives for medical malpractice reform. Now, don't think about this in terms of whether or not medical malpractice is a good idea. That's not the question. It may be a very good idea. The question is whether it's constitutional authority. The typical malpractice, and by the way, the conservatives say, yeah, it's authorized, it's a regulation of interstate commerce. Well, the typical malpractice case is an in-state patient suing an in-state doctor for an injury that occurred all in one state, and there's no way that can morph into a regulation of interstate commerce. The libertarian view is pretty straightforward. No matter how worthwhile the goal may be, no matter how much Congress is absolutely certain it's identified a big problem and it knows the answer to the problem, if there's no constitutional authority, the federal government has to step aside and leave the matter up to the states, or even better yet, up to private parties. Now, that was the intent of the framers. That's not what has transpired. Today, the federal government has immersed itself in matters ranging and as I read this list off, you think about which ones are authorized by the Constitution. Public schools, federal government, public schools, hurricane relief, drug enforcement, welfare, our retirement system, our medical care system, family planning, housing, even aid to the arts. Not a single one of those can be found among Congress's enumerated powers. Now, there's a second area where conservatives and libertarians differ with respect to powers of government, and that is that conservatives are less anxious than libertarians about assigning a whole lot of power to the executive branch, particularly when it comes to this trade-off between national security and civil liberties. Libertarians remind their conservative friends that too much unchecked authority in one branch, in the executive branch, threatens the whole notion of separation of powers that was a cornerstone of the Constitution and has served us well for more than 2 centuries. So the administration, and I'm sorry to say, I mean most particularly the George W. Bush administration, may not by itself set the rules, because setting the rules is not an executive function, it's a legislative function. And while the administration may prosecute infractions and enforce the rules, it may not after the fact determine whether or not its own actions have complied with the Constitution, because that's not an executive function, that is a judicial function. So that's the powers of government perspective, grounded on the 10th Amendment and the separation of powers doctrine. Now, I also mentioned the 9th Amendment. The 9th Amendment doesn't talk about powers, it talks about rights. And what it says in a nutshell is that the enumeration of certain rights in the Constitution is not meant to be limiting. Those are not all the rights that we have. We have lots of rights that are not listed in the Constitution, rights that we had before the Constitution was ever written and before the U.S. government was ever formed. And that safeguard imposes another powerful discipline on federal behavior. Because what it says is that even if the federal government is exercising its very limited powers in accordance with the 10th Amendment, the ones that are enumerated in Article 1, Section 8, the 9th Amendment says, even if you only exercise those limited powers, you can't exercise those powers in a manner which violates our rights. And if you want to know which rights can't be violated, you look, says the 9th Amendment, not only to the ones that are listed in the Constitution, speech, religion, press, protection against unreasonable searches, etc. You look to unenumerated rights as well. And that would include, in the libertarian view, things like the right to gamble, for example, or the right to smoke marijuana. Now, if you wanted to capture the whole essence of the Constitution and the federal structure, just take a look at how the presumptions underlying the 9th and 10th Amendment are exactly opposite one another. The 10th Amendment says if the power isn't there, the government doesn't have it. The 9th Amendment says the reverse. Just because the right isn't there doesn't mean that we don't have it. We have lots of rights. So if one wanted to identify a single constitutional provision that most distinguish conservatives from libertarians, it would be the Ninth Amendment. Our former Judge Robert Bork says the Ninth Amendment should be treated as, and to use his memorable term, an ink blot. It should be ignored. Nobody knows what it means. It's as if somebody spilled ink on the portion of the Ninth Amendment that would have identified these unenumerated rights that the libertarians insist that we have. Libertarians, on the other hand, treat the Ninth Amendment like it means something. It refers to our natural rights, the rights that we have just by our very nature, pre-government, pre-constitution rights that we still retain. In short, all of the so-called negative rights. Now, it sounds like a pejorative term. It's not meant to be. A negative right is simply a right that doesn't impose an affirmative obligation on other people. By contrast, a positive right, or what really ought to be called an entitlement, does impose affirmative obligations on other people. So let's take, for example, the right to the pursuit of happiness. That's a negative right. I can pursue happiness, and I do not need your help. I just need you not to use force against me, not to use fraud against me. Negative obligations. No positive obligations on your part. You don't have to do anything affirmatively to enable me to pursue happiness. I can do it on my own. Suppose, however, I had a right to happiness. Not the pursuit, but the attainment, the realization of happiness. Now, as you can imagine, that's a positive right because it does impose affirmative obligations on each and every one of you. If I have an enforceable right to happiness such that if I'm not happy, I can go do something about it, go to court, get redress, then obviously none of you could do anything that would make me unhappy. And if you did, I could prevent you from doing it. Of course, that would impede your own right to the pursuit of happiness. So these positive rights, these are integral to the liberal view of the proper role of government. Since I've been somewhat critical of conservatives, let me be an equal opportunity critic. We have all of these all of these government programs, like health care, medical care. These are the positive rights that we ordinarily hear about. Housing, medical care, welfare, minimum wage, and on and on. Look, if I have a right to housing, somebody has the obligation to either provide me with a house or provide me with the means by which I can acquire the house. So clearly, a right to high housing is a positive right, and these are ordinarily programs that are embraced by liberals, even though they involve big government. But paradoxically, we're hearing from liberals in the post-9/11 era that they're concerned about big government in one single area, and that is this trade-off between national security and civil liberties. But one wonders, where does the left stand that's so concerned about big government regarding big government control over things like our retirement system or our public school system or the private economy? Why hasn't the left's, I think, very healthy distrust of big government in the civil liberties area, why hasn't that extended to things like support for privatized Social Security or school choice, or the elimination of regulations that control everything from the size of a navel orange to the ergonomics of office equipment? Why is it that liberals can't see past two particular government agencies? Big government's fine, as long as it's not the Justice Department or the Defense Department. And oddly enough, those two agencies are charged, I think, with an indisputably legitimate function of government, and that is to protect us from domestic and foreign predators. So imagine if the Congress were to delegate to John Ashcroft at the Justice Department or Alberto Gonzales, say to the Justice Department, you have the authority to pass regulations regarding the trade-off between national security and civil liberties. Here's your guideline. Keep us safe from the terrorists. Now, people on the left would be apoplectic, and they'd have every reason to be apoplectic. It is not the Justice Department's role to make rules. It's the legislature, the Congress's role. But when the same Congress turns around and delegates to the Environmental Protection Agency the authority to pass regulations regarding the trade-off between a clean environment and economic growth, and it gives the EPA no more guidance than keep us safe from pollutants, the folks on the left applaud enthusiastically. So is it the case that pollutants are a greater threat than terrorists? Not likely. What's more likely is that the left has a selective indignation about big government, and that reflects an inconsistency in the liberal mindset, just as there is, on occasion, an inconsistency in the conservative mindset about what is the proper role of government. Of course, that is the foundational question, the proper role of government. And in examining that question, the Constitution, I would suggest, can be viewed succinctly through these two prisms. The powers of government prism, that's the 10th Amendment, the rights of individuals prism, that's the the Ninth Amendment, and if you want the libertarian view in a nutshell, it is that the powers of government have to be interpreted very narrowly, and the rights of individuals have to be interpreted very broadly, and that was precisely the vision of the framers. So that's the background, and now let me turn to a couple of the cases. By the way, it's been 218 years since the Bill of Rights was ratified. During that time, we've only had 17 more amendments, which is quite extraordinary, 17 amendments in 218 years. Why so few changes? Well, I can think of lots of reasons, but three of them are particularly relevant to this talk. Two of the reasons are good reasons, one's not so good. The first good reason is that the Constitution is an incredibly well-crafted document written by brilliant legal minds who had a vision of liberty that was every bit as relevant then as it is now. The second good reason is that in exercising their genius, they had the foresight to put into the Constitution an amendment process. Essentially, 2/3 of both houses have to propose amendments, have to be ratified by 3/4 of the states. That's a difficult process, and not surprisingly, we haven't had very many times when that process has been implemented. As a result, we have a very stable form of government. The one not so good reason that we haven't had very many amendments is that the Supreme Court, in my view, has accomplished through the back door what the Congress and the states could not have accomplished through the prescribed amendment process. Regrettably, the modern Supreme Court, I think, has lost its compass, and that has profound implications for all of us. Now, some of the damage occurred early on. You remember, I'm sure, heard of maybe the worst case of all, Dred Scott v. Sanford, 1857. The court said that black slaves were property and not citizens of the United States. And Plessy v. Ferguson, the 1890 case where the court upheld a Louisiana statute that required, not just permitted, but required railroads to provide separate but equal accommodations to the white and colored races. Now, as repugnant as those cases are, they're not in the book because they're no longer the law of the land. Dred Scott was superseded by the 14th Amendment, and then Plessy by a whole series of cases, beginning with the 1954 school desegregation case, Brown versus Board of Education. So much of the court's mischief that has enduring significance, lasting significance, occurred much later than the 1800s. It occurred during the New Deal and beyond, the 1930s and beyond. And that's the focus of the book, from the New Deal and beyond. So let me tell you about 4 or 5 of the cases with just a few sentences about each one. These are in no particular order. It's not the worst case and the worst, et cetera. It's just sort of powers of governments and the rights of individuals. Interestingly, these cases have real significance in today's environment. The first case is whether or not the Social Security system is constitutional. Is there constitutional authority for the Social Security system? Halvering v. Davis, 1937. Now, again, the question is not whether Social Security is a good idea, or whether the system is actuarially sound, whether, in fact, the government should be providing for our retirement. The question is there a provision in the Constitution that authorizes the Social Security system? And, of course, you can substitute health care for Social Security, substitute Medicare, Medicaid, substitute any of these federal health programs that are being debated. It's the same issue. Is there a constitutional provision? The proponent said, yes, it's authorized under the General Welfare Clause. Congress has the authority to tax in order to promote the general welfare. And this was a battle between Hamilton and Madison. Hamilton said the promotion of the general welfare, did I say Madison? Hamilton said the promotion of the general welfare is an extra added hour of power of Congress. Now, Congress can, post offices and coin money and all of that. And in addition, it has the power to tax in order to promote the general welfare. Madison said that can't be the case. The whole structure of the Constitution, the nature of the system of government that we're establishing, is limited powers. Everything can be couched as promoting the general welfare. If Congress has an additional power to do anything that promotes the general welfare, then Congress's power is unbounded. In fact, Madison even went a step further. He said not only isn't the General Welfare Clause a means of a method by which Congress can add to its powers, it actually diminishes its powers. It's another restriction. What it means is that Congress has all these powers that are enumerated in the Constitution, like coining money, etc. And in addition, when Congress exercises those powers, it must do so in a manner that promotes the general welfare and not the welfare of what Madison called factions and what we today call the special interests. Well, long story short, the court looked at it and said Hamilton wins, Madison loses. The Social Security system is constitutional. That means Medicare is constitutional, Medicaid is constitutional. I would argue none of them is constitutional. That opened up the redistributive state, the floodgates for the redistributive state, and that means taking money from some people, giving it to other people without any constitutional constraints whatsoever. Second case is about the Commerce Clause. You'll spend a lot of time on the Commerce Clause in your constitutional law class. The case is a 1942 case. I could have picked any number of several cases, but this one's a 1942 case called Wicker v. Filburn. Congress does, the federal government, Congress has the power expressly enumerated to regulate interstate commerce. So the issue at Wicker v. Filburn is pretty straightforward. Does the power to regulate interstate commerce extend to activities that are not interstate and not commerce? Seems like a pretty simple question. It wasn't so simple. Mr. Filburn grew crops on his farm all within one state. He didn't buy the crops, he grew them. And he didn't sell anything that he grew beyond a minimal amount. He actually consumed it all and gave the rest of it to his farm animals. And the Roosevelt administration came in and said, look, we're in a depression. We need to prop up the price of farm products. We need to control the amount of production. Filburn says under what authority? Roosevelt says regulating interstate commerce. Filburn says quite sensibly, this is not interstate commerce. It's all on my farm, one state. I'm not doing any buying. I'm growing. I'm not doing any selling. I'm eating. So there's no interstate. There's no commerce. The Supreme Court looks at it and says, Filburn, you just don't get it, do you? I mean, after all, said the court, if you weren't out there growing this stuff, you probably would have had to buy it. And if you didn't eat everything you grew, you would have had some left over to sell. So by not buying and not selling, we add together all the other people that are probably doing the same thing you are, there's going to be a substantial effect on the supply and demand of crops, which would affect the interstate markets, and so we can regulate you. That, of course, opened up a second set of floodgates for the regulatory state, the ability to regulate just about anything and everything under the rubric of the Commerce Clause, and it is being cited as the source of many of the powers that are being exercised today to resolve our economic turmoil. A third case that has implications for today's economic situation is a case involving the Contracts Clause called Home Building and Loan versus Blaisdell, 1934 case. Again, another New Deal case. The Contracts Clause is really crystalline. It couldn't be clearer. And this is what it says in the Constitution. No state shall pass any law impairing the obligation of contracts. Well, that wasn't clear enough for the Supreme Court. The Supreme Court upheld a Minnesota statute which postponed, see if this sounds familiar, mortgage payments for financially troubled homeowners. And this was all mortgage payments for troubled homeowners, not just those that were fraudulently induced. You know, you hear that a lot of people signed mortgages because they didn't understand them. There's no doubt truth in that. Mortgages that are fraudulently induced are not enforceable, and there are plenty of laws on the books that take care of fraud in the inducement of a contract. But this provision in Minnesota, being repeated today, is a waiver of foreclosure rights for all mortgages. Next case, also implications today. It's about a clause that you probably don't spend much time on in common law. It's called the Nod Delegation Clause. The case is called Whitman versus American Trucking. And the Nod Delegation Clause is the very first sentence in the Constitution, right after the preamble. The very first sentence says all legislative power is vested in Congress. Why? Well, because the framers were pretty smart and they knew if Congress passes laws we don't like, we vote the bums out of office. Well, maybe not. Suppose Congress passes laws that nobody knows what they mean. And then they delegate the authority to flesh out the details to one of these 330 or so alphabet agencies and executive departments, cabinet departments, located in Washington, D.C. Well, then the voters can't vote the bums out of office because these agencies and executive departments are not run by elected representatives. They were run by unelected bureaucrats. And not only can't the voters do much, but apparently the courts are not going to do much either. And if you like this principle that Congress can delegate its legislative authority, then you will love TARP, the Troubled Asset Relief Program, or what we now know as the bailout. Originally giving former Secretary Henry Paulson virtually carte blanche to purchase toxic assets from troubled financial institutions, but Paulson changed his mind, and without any congressional authority, he decided, I'm not going to do that. What I'm going to do is put direct injections of capital into these institutions. Well, and then Geithner came along, his successor, and decided, no, what we really need is a public-private partnership, whereby all of the money that comes up is from the public, namely the taxpayer, and all the benefits go to the private, namely the bankers and the other financial institutions. Along the way, the administration expropriates a few tens of billions of dollars to bail out the automobile companies and $180 billion to bail out insurance giant AIG. All of this done, particularly to auto companies, that Congress expressly disapproved of a bailout of the auto companies. All of this done under the authority of the Secretary of the Treasury, exercising legislative powers. Now, what have the courts said? In a nutshell, they've said, you know, the Constitution says you can't do it, but government's complicated. We really need all of these experts at these 300 and some agencies, and so we're going to make an exception. And the exception is you can delegate that power as long as Congress lays down an intelligible principle so that these executive departments and agencies, they know how to conform these rulemaking functions that they have to carry out the intent of Congress. What is the intelligible principle that Timothy Geithner has to follow with respect to TARP? Nobody knows. Nobody has the foggiest idea, least of all the taxpayers that are footing the bill. The intelligible principle seems to be make things better. And that is hardly a coherent guide for policy. And then finally, one further case, and that is involving campaign finance reform, obviously of relevance even today because the Supreme Court just heard an interesting argument in a case called Citizens United versus FEC. But the campaign finance reform I'm talking about was a 2003 case called Mcconnell versus Federal Election Commission. This is a case involving the constitutionality of BICRA, BCRA, the Bipartisan Campaign Reform Act, which we popularly know as McCain-Feingold. Now, there's this quixotic idea on the part of campaign finance reformers that we got to get money in politics and get money out of the mix. And in pursuit of that idea, the court has curtailed our most basic expressive right, the right that the First Amendment was absolutely designed to protect, and that is the right to support or criticize political candidates. And what's the justification? It's not to eliminate corruption, because there are plenty of laws on the books to do that. It's to eliminate the appearance of corruption. Of course, nobody knows what that may mean. But what it has meant in practice is that political speech, the very essence of First Amendment protection, gets less protection under the First Amendment than, for example, Klan speech, pornography, or flag burning, all of which is protected, but political speech, very draconian restrictions imposed on political speech. Now, why? Well, it's because Congress doesn't understand that politics is all about a bargain that takes place between the candidate on the one hand and the voter on the other. The candidate says, I'm going to follow certain policies, Mr. Voter, Mrs. Voter, and in return, I want you to do something for me. There should be no constitutional significance to whether the voter's return promise is, okay, candidate, you follow these policies that I like, and I will. Either I'll vote for you, or maybe I'll convince some friends to vote for you, or I'll write a letter to the editor supporting your candidacy, or I'll pay for an ad and take it out in the newspaper, or I'll give you some money and you take out your own ad in the newspaper. See, each of those has the same ends in mind, and that's getting this guy elected. And they each operate through the same means, and that's political speech, protected political speech. So this trade-off of political speech for promises from a candidate, it's not corruption, it's not the appearance of corruption, it's the whole political process, it's the way democracy works in this country. That doesn't mean everything should be legal. If you're not trading political speech, but you're trading personal favors, like follow these policies, Mr. Candidate, and I'll buy you a new boat, or you'll take a trip to the Bahamas, that's not the exchange of political speech, and that obviously should be ruled illegal, and it is under current law. But we can't treat the First Amendment like it's a loophole, otherwise there is no purpose in having a written constitution. So in a free society, we shouldn't have to ask for government permission to engage in political advocacy. We shouldn't have to, some of you remember the eminent domain case, we shouldn't have to allow government to take private property from one private owner and turn it over to another private guy who says he's going to increase the tax base to build a hotel or an office building. Now, these abuses of power, they can be minimized, but only if the Supreme Court ensures that the legislative and the executive branches are bound by the chains of the Constitution, and I think, regrettably, the court has, again, more than one occasion, been derelict in fulfilling that obligation. And that is the story of the Dirty Dozen. So thanks very much for your attention.
We have just a few minutes, if you wouldn't mind taking a few questions. And since I get to come up here, I get to ask the first question. You spent a lot of work being involved with the DC v. Heller case that has come down recently, the case about gun rights, for those of you who don't know. I was just wondering if you could talk a little bit about the next obstacle seems to be incorporating our newly rediscovered Second Amendment right. I was wondering if you could say a few words about that.
We being myself and two other attorneys, filed this lawsuit, DC v. Heller, 2003. It took us 6 years to litigate it. It ended up, as some of you know, as a victory in the Supreme Court in June of 2008. The preceding jurisprudence was that there is no individual right to keep and bear arms unless it's connected to service in the militia. The current ruling in the Heller case is an unequivocal declaration by the court that the Second Amendment does secure an individual right to keep and bear privately owned firearms in the home for self-defense, even if independent from militia context. Now, we brought this suit in Washington, D.C. for a lot of reasons. One reason was that it had an incredibly high rate of violence, and the second was it had an outright ban. It was the worst, most draconian ban in the country. No handguns for all people at all times, in all places, for all purposes, just an outright ban. So that was a good combination of facts for us. But there are a couple other reasons. Most importantly, for your purposes of your question, we brought it in Washington, D.C. because it is in the state. And as you'll find out again when you study con law, when the Bill of Rights was first passed, including the Second Amendment first ratified, it only applied to the federal government. You look at the First Amendment, it says Congress shall make no law. It didn't apply to the states. And that's because we thought we needed protection against federal government tyranny. Of course, we found out over 80 years that the states can be every bit as tyrannical as the federal government, witness slavery. And so we had a civil war, and we had a few constitutional amendments after that, one of which was the 14th. The 14th Amendment has been used ever since the post-Civil War period to incorporate, that is, to apply the Bill of Rights to the states, to make the states responsible for not violating the rights that are secured in the Bill of Rights. But it wasn't done all in one fell swoop. It was done not even amendment by amendment. It was provision by provision. So there would be one case incorporating the speech rights, one press, one religion, one for unreasonable searches. The Second Amendment's never been litigated, so there was no determination as to whether the Second Amendment applies to the states. We brought the case in D.C. so we could avoid that problem. We wanted a nice, clean, what does the Second Amendment mean case, not where does the Second Amendment apply. Now, by bringing it in D.C. and by getting the declaration that we wanted, being successful in D.C., we did reserve this question to the next round, and that is, does the Second Amendment apply to the states? And there is now a new case that the Supreme Court just granted cert called Mcconnell versus Chicago, which will test this very thing. Chicago has a gun ban that's very similar to the gun ban that was in effect in D.C., so one would think if the Second Amendment applies to Chicago and to the state of Illinois, then that gun ban's got to go. And indeed it does, if the court says that the Second Amendment is applicable. And that's the question that the court's going to have to resolve. I am very confident that the court will say that the Second Amendment is applicable in Illinois and all the other states. I mean, can you imagine a provision in the Bill of Rights like the Second Amendment that under current law now is applicable in Washington, D.C., and all the other federal protectorates like Guam, Samoa, the Virgin Islands, Puerto Rico, but not in Illinois? You don't have the same rights that you have in Guam under the Second Amendment. So it will be incorporated. The more interesting question is whether the incorporation is going to be by the Due Process Clause, which has been the way in which, of the Due Process Clause of the 14th Amendment, that's the way in which most of these rights have been incorporated. Or will the court revisit a case that was decided in 1873 called the Slaughterhouse Cases, which erased from the Constitution the Privileges or Immunities Clause, and a lot of us are arguing, libertarians in particular, that the vehicle for applying the Bill of Rights to the states, the Second Amendment in particular, should be the Privileges or Immunities Clause, not the Due Process Clause. Why? Because the Privileges or Immunities Clause incorporates a lot more than gun rights. And most importantly to libertarians, it incorporates economic liberties. The right to contract, the right to property, the right to start a business, without being told you have to jump through 300 hoops, the right for inner city minority folks to take the first step up the economic ladder without being plagued by regulations that are put in place by vested interests that have political clout, that go to their state or city councils and ask for rules that will make sure we don't have any competition. So these are rules that basically oppress mostly inner city, mostly minority folks that would like to be entrepreneurs but find that they can't do so. If we can determine that the Privileges or Immunities Clause applies the Bill of Rights to the states, maybe we can also get the court to consider that the Privileges or Immunities Clause is much broader than the Bill of Rights and includes some of the economic liberties. So I'm sorry for the long answer, but that's one thing that is still at issue after Heller. There is a second thing that's still at issue, and that is Heller was about the right to own an ordinary garden variety pistol in your home. So it wasn't about, machine guns. It wasn't about carrying outside the home. It was about a very simple issue, having a pistol in the home for self-defense. So the scope of this right, now that the Supreme Court said it's an individual right, we still don't know what kinds of regulations are going to be okay. It's not an absolute right any more than the First Amendment. First Amendment, Congress shall make no law infringing on free speech. Well, we got laws against defamation, laws against incitement to riot, shouting fire in a crowded theater, lying in commercial advertising, laws, as I just mentioned, about naming a candidate for political office and a broadcast advertisement within 60 days of an election. There are all kinds of restrictions on free speech, even though it says Congress shall make no law. In the same sense, the Second Amendment is not absolute. So you're going to be able to keep guns away from kids. You're going to be able to keep guns away from crazy people and from people that have long records of violent felonies. You're going to be able to keep some weapons away from everybody. The Second Amendment couldn't possibly mean that we each have an absolute right to have a weapon of mass destruction in our living room. So the scope of that right is going to have to be determined, and that's going to have to be done with future litigation. We took this one step at a time. Heller was a very minor but important first step. That's the way Thurgood Marshall did it in civil rights cases. Don't bite off more than you can chew. It's sort of an incremental approach to making constitutional progress in the courts.
Any more questions?
Yes, sir.
How would you respond to the following defense of traditional liberalism, traditional conservatism that you were saying are ideologically inconsistent, and the defense is that the ideology behind liberalism is change which economically happens by government involvement and socially happens by restricting government involvement, and the ideology that unites conservatism both on economic and social issues is orthodoxy, which economically happens by limiting the size of government, socially happens by having the government be involved in people's personal lives. Do you find that consistent with the role of the court or not?
Well, I suppose my response would be at a more basic level, and that is that I'm talking about constitutional jurisprudence, not ideology. I'm not talking about the preferences of the liberals or the preferences of the conservatives. I'm talking about the mandates that are contained in the U.S. Constitution. So the text of the Constitution is an anchor. It's an objective means by which we can determine that which is appropriate and which isn't. If we don't like it, we have a means of amending the Constitution in Article 5. We cannot treat the Constitution, as some on the left in particular would like to do, as a living document that's malleable, that can be flexibly altered to meet changing societal and economic and cultural circumstances. When we do that, we don't have a written Constitution at all. We just have a series of political preferences, which is, by the way, why the whole judicial confirmation process is dysfunctional now. Because there is this movement toward this living constitutionalism where we're worried about implementing various ideological preferences. So when that happens, when you treat the Constitution as this alterable document where there's no anchor in the words of the document, then the confirmation process and judging itself just becomes politics by another name. So no wonder all of the people on both sides of the aisle want to know what the views of the judges, of the nominees, are on these various political issues that are extant today. Because those views might be codified in law at some point, notwithstanding the fact that there are express provisions in the document that would suggest otherwise. So I would answer that what matters to me as a constitutional lawyer is the text of the Constitution and what that says about the jurisprudence that results, not the ideological or policy preferences of either liberals or conservatives.
I think we have one down here as well.
Thank you. How do you think incorporating individual rights of the states would affect handgun concealment laws or state statutes that affect the transportation of handguns from the place of purchase to the home?
Well, we're going to find out because there's another case that's now pending in Washington, D.C. It was actually just filed, so we haven't had even a trial court judgment, and that is Palmer versus District of Columbia. Palmer, I'm happy to say, is Tom Palmer, who is my colleague at the Cato Institute, and who was also one of the 6 plaintiffs in the Heller case. Palmer has asked that D.C. overturn its concealed carry ban. So remember, step one was simply guns in the home for self-defense, privately owned guns independent of militia context. We've gotten that step. Now, D.C. also bans any carry of anything at any time, everywhere, outside of the home. And Palmer has said in his complaint, look, now we know there is an individual right to not only keep arms, but bear arms. Look up bear in the dictionary, it means carry. And so while D.C. can regulate that, and Justice Scalia was very clear in saying that even though we uphold an individual right, there are areas that the government can regulate. So even though D.C. can regulate carry by some people, like crazy folks, or carry of some weapons, like bazookas, or carry in sensitive places, like 10 feet away from the president when he's making a political speech, even though the city can regulate that, the city cannot ban and carry across the board for everybody at all times and all places. So that will be tested. I think that on the merits that the outright ban on concealed carry in D.C. is unconstitutional. But the question will be, what is the scope of the regulations that we permit? And by the way, that scope may end up being geographically contextual. So what works in the hills of Montana doesn't have to work in downtown Washington, D.C. They will certainly, or should certainly, be given more leeway to regulate in an environment of an inner city than you would have in the rural areas. Sir?
I know in Kansas last year in June we legalized the possession of NFA firearms, such as machine guns, silencers, and other NFA firearms. Are there any cases in Washington, D.C. that you know that has to deal with NFA firearms?
No, there aren't any cases. Of course, Washington, D.C. is only since June of 2008, allowed the possession of even handguns. And what the problem is in Washington, D.C. is that now we have a law that says you can possess handguns, but we don't have any place you can get them. Why? Well, because business people are not stupid. When you have a handgun ban for 33 years, nobody opens up a gun store to sell handguns. And so there are no gun stores in Washington, D.C., literally. No gun stores in Washington, D.C. How do you get a handgun? There's one guy in Washington, D.C. who has agreed to accept shipments from outside the state. Why aren't there more? Well, in a free market, you would expect there to be more because now we have an individual right. There aren't more because D.C. has imposed some very strict provisions respecting the opening of a dealership. And those will be challenged, there's no question of that. But in answer to your question, I don't know of any cases involving NFA firearms. NFA, National Firearms Act.
We have time for maybe one more question for Ian.
Under a libertarian judicial rubric, when you're looking at the Ninth Amendment, how do you determine and who makes the determination of what is a valid unenumerated right and what is an invalid unenumerated right?
Well, I've suggested one framework, and that is this categorization of rights, bifurcation of rights into positive and negative, where the negative rights do not impose obligations on other people and the positive rights do. Now, it's pretty clear that the Ninth Amendment can't be referring to positive rights. If we take a positive right we're all familiar with, let's say the right to education. Education, if you have a right to education, an enforceable right, such that if you don't get some quantity of education, you can do something about it and force the provision of that education. Somebody somewhere has the responsibility of paying for it or arranging for it to be provided. And so it's quite clearly a restriction on that somebody's ability to pursue his own liberty. So the Ninth Amendment can't be referring to rights that are applicable to some people at the expense of others. And therefore, the Ninth Amendment must refer only to these negative rights that don't impose affirmative obligations on other people. So that's the rubric that I would argue is the appropriate one.
All right, if you guys just give one more round of applause.